Now, without further ado, we are going to bring up a family member that has been fighting furiously for the truth about what happened to his brother, Geoff. Matt Campbell is with us. He's also featured in Dylan Avery, my partner, and really the mastermind behind Loose Change, the film The Unspeakable with Bob McElveen, who's going to be joining us virtually afterwards. Come on up here, Matt.
Hello, everyone. Thank you for coming, and thank you for watching if you're online. This is the story of my family's fight to secure a proper investigation into my brother's death, his murder. Many of the British victims of 9/11 were on the 106th floor of the North Tower at a conference organised by the British company called Risk Waters. 10 Brits were killed at that conference, 8 were employees, 2 were conference attendees. Geoff was one of those attendees. And this clip, taken from a boat on the Hudson River 24 years ago today, is probably the last seconds of his life. Geoff with a G was just 31, a year younger than me. He was intelligent and successful at everything he did. He was athletic. He played badminton for England as a teenager. He played chess to a high standard, often beating our younger brother Rob, who himself played chess for England as a junior. Geoff always had time for people. He enjoyed life and was fun to be around. Mum and Geoff were very close. That's a photo of them taken on Mother's Day in 2001. It's not been easy over the last 24 years. I still miss him. We all do. Okay, I'm going to be talking about stuff in the UK. When someone has a death that was violent, unnatural, or the cause is unknown after a post-mortem examination, an inquest is held in the UK in a coroner's court. And nearly 3,000 people were killed on 9/11. Most suffered a violent death. 67 were British victims, citizens, and families need answers. And an inquest is a court investigation into a death. It doesn't assign blame, it establishes the facts: who died, when, where, and how. In January 2013, a joint inquest was held into the deaths of 10 of the 67 British victims. All were from the North and South Towers. 4 of the victims, including Geoff, were at the Risk Waters conference. 3 of the victims were heavily fragmented, like Geoff. His remains had been identified up to this point in 2002, 2004, and 2008. Tiny fragments, a handful of small bones, part of his jaw, 3 teeth, his ear, part of his face, his hair, and his scalp. Horrific, really. Less than 5% of his body has been identified in total, and I'll come back to that on a later slide. However, one victim from the 106th floor was 86% intact. His father is on record at the inquest, struggling to comprehend how nearly all the 10 British victims, not just those from the 106th floor, were so fragmented. It was a shock to him, as his son was so complete. What can cause that range of and degree of fragmentation? The coroner didn't look into it. I'll try not to laugh while I go through this bit. This is the UK investigation. The UK coroner relied on a report prepared by the British Police SO15 Counter-Terrorism Command Unit. The report is astonishing. A 1-page executive summary, that's it. 2 pages of nothing more than a timeline of the events of AA11 and UA175 and the impacts and collapses of the North and South Tower. And finally, a rather peculiar 1-page summary from the FBI regarding the prosecution of Zacarias Masui. 4 pages. Essentially a cut and paste, very small cut and paste from the US. No investigation whatsoever. No evidence relevant to the crucial issue of causation of death was put forward. The inquest lasted less than 2 hours for all 10 victims, of which only 3 months was spent specifically dealing with my brother's life and his death. They even ignored his third set of remains identified in 2008. There was no press coverage whatsoever. Inquests are not supposed to be about going through the motions. Now, this is what the coroner concluded. If you can see it on the screen, ignore the wrong year of death, 2011. Medical cause of death, multiple injuries. In the US, you call it blunt trauma. And it was in an unlawful killing in an act of terrorism overseas. Now, although the scope of an inquest is relatively narrow, applying a broader narrative to the circumstances of death is now common. So the narrative conclusion stated, at 8:46 on the 11th of September 2001, the deceased was on the 106th floor of the North Tower of the World Trade Center when an aircraft, AA-11, was deliberately flown into the building, causing its collapse at 10:28. This event was part of a coordinated attack by the Islamist militant group Al-Qaeda. Now, my family is only challenging the conclusion that the plane's impact and fire brought down the tower. However, in a new inquest, we would ensure that the coroner has to evidence all statements given in any narrative conclusion. So I want to return briefly to the degree of fragmentation my brother suffered, along with many others. These are the latest stats from September the 1st this year. So you've got nearly 22,000 body parts, and according to the Office of the Chief Medical Examiner, 5,000 of those fragments are less than an inch in size. And there have been 3 new identifications this year. The year before, just 1. The year before, 2. And I think in total, there's only been 14, 15 new identifications in the last 10 years. So unless there's a massive leap forward in technology, I suspect the majority of the 40% of victims, that's 1,100 people, will remain unidentified. I want to show in a bit more detail just how fragmented many of the victims were. Now, this chart is adapted from a paper published in the Forensic Science International Journal. There's actually an error. I got ChatGPT to do this and it's got the numbers wrong. It's bad at maths. So if you look at the first 2 columns, I say here on average 30% of the identified World Trade Center victims had less than 5% of their bodies recovered. Actually, it's closer to 25% for World Trade Center 1 and 28% for World Trade Center 2. But what you need to think about is that's of the victims who have been identified. If you then take into account the 1,100 not identified, the true figure is probably at least 50%. This illustrates the extreme fragmentation of victims. The degree of fragmentation isn't normal in a building collapse. I've seen photos of victims in situ from building collapses, from earthquakes, etc. The victims are crushed, but essentially whole. Okay. So, although this is odd to say in front of a mostly US audience, I've always thought for the last 10 years or so that the quickest way of getting the evidence for controlled demolition into a court of law is via an inquest in the UK. I still think it's the best chance, but it certainly hasn't been easy nor quick. So Section 13(1)(b) of the 1988 Coroners Act provides a statutory route for reopening an inquest where it is considered that it is necessary or desirable in the interest of justice for another inquest to be held. And many, many families in the UK have used this mechanism to reopen a loved one's inquest when new evidence has come to light. However, the statute does not give the family a direct right to apply to the court. We have to ask permission from the Attorney General for England and Wales. So at every stage, which is so frustrating, I don't know if it's different in this country, but we're talking lower courts at the moment, we've had to ask permission to move forward. It costs both money and time. And it's a bit of a theme that's developed over the last 4 years. I'll try and briefly summarise what's happened and how a relatively straightforward inquest application has turned into a litigation quagmire. However, each hurdle successfully overcome is taking me closer to justice for Geoff. And so it began. So the definition of lawfare is the strategic use of legal proceedings to intimidate or hinder an opponent. And I've pretty much been at war for the last 4 years. So here's a very quick recap for those that don't know a little bit of the history of what I've been trying to do. In the summer of 2020, with architects and engineers for 9/11 Truth's help, work began preparing an application with my barrister, Nick Stanage, from Doughty Street Chambers in the UK. Ted Walter spent many hundreds of hours working on that application, and he still continues to this day to help me. Thank you, Ted. In August 2021, a 2,500-page application was submitted to the Attorney General. The application contained new evidence which had not been put before the coroner at the first inquest. The new evidence was eyewitness and expert testimony, evidence of explosives and incendiaries, analysis of the Twin Towers' downward motion and explosive behaviour, seismic evidence of explosions, demonstrable inadequacy of the NIST investigation, as well as supportive signed statements from victim family members in the US. On paper, granting permission to reopen my brother's inquest looked like an easy decision for the AG. We expected an answer within a few months. But no. We waited a very long 22 months for a decision. And in June 2023, we received a terse, almost laughable letter of refusal, which was unreasonable, irrational, and unlawful. I'm using legal terms there. We immediately set about raising funds to challenge the decision in the High Court with what's called a judicial review. And by law, you only have 3 months to do that from when the decision is made. Essentially, you apply, asking for permission, first, of course, to the High Court to assess whether a decision made by an authority is a lawful one. And again, this is a mechanism that's used a lot in the UK. We threatened this legal action of judicial review because their decision was so outrageous. And they had no choice but to withdraw their decision because they knew they would lose. They said they would make a new decision in due course, and there was nothing we could do about that. 4 months later, in January 2024, we received a second refusal. To be honest, this one wasn't much better. And again, we had no choice but to go down the path of judicial review. 3 months to raise yet more substantial funds and submit an application asking for permission. And again, with the generous support of the public, we made it just in time. The application was filed and served with only minutes to go to the 3-minute deadline. It's almost impossible to compete against the unlimited resources of the AG. However, there is a mechanism, and we used it. We applied and got a time extension to finish completing the lengthy application, which took us until September 2024. Now it was running into 9,500 pages. The Attorney General submitted their grounds in October 2024, and for the first time used the defence that their decision is non-justiciable, i.e. they're above the law. The courts can't look at their decision. It's their trump card, if you like. No pun intended. We awaited the court's decision. So in December of last year, the judge who looked at our application took the very unusual step of ordering a preliminary issue hearing. Now, the preliminary issue was that of justiciability, i.e., are the Attorney General's decisions reviewable by the courts? That had to be decided first before the court looked at our 9,500 page application for permission for judicial review. Remember, all this started with a standard request to reopen an inquest. And we are now looking at funding and fighting an almost abstract bit of constitutional law that frankly was something I feel that the judiciary and the government should sort out amongst themselves. Let them step outside and fight it out. Talking of being outside, that's a photo of my lovely 80-year-old mum and me outside the High Court in June this year. What's rather alarming to me, and I reflected on it a few days ago, is I'm actually my mum's age now when my brother was murdered. I hope I'm not still fighting for truth and justice when I reach 80. So, the preliminary issue hearing. To increase our chances of success at the High Court in what had become essentially a constitutional matter, I not only had a proper haircut and wore a suit, but I also engaged a King's Counsel barrister for the first time. I had to, as the Attorney General had engaged their best KC, Sir James Eadie. That's the government's go-to man for all big government cases. Now, the one-day hearing was held in front of two judges. One was a young, progressive judge who had actually ordered the preliminary issue hearing in the first place. And the older judge was more of a sort of dyed-in-the-wool, old-fashioned sort of guy. It was clear that the younger judge was receptive to our arguments, and the old boy less so, clearly lapping up every word Sir James Eadie said. I won't bore you with the legal minutiae, but we put up a good fight. My KC delivered a healthy mix of self-deprecating humour and the occasional outburst, asking things like, why on earth did it take 22 months for the Attorney General to make that first decision? And then why do they continue to resist the reopening of my brother's inquest, which should have been granted? My KC even mused out loud at one point, has a trade deal been promised with President Trump if the British government prevents my client's family from seeking justice? He also sarcastically thanked Sir James Eadie's masterclass in legal gobbledygook, as there was little substance to his arguments, just lots of Latin words. Anyway, the ruling was handed down a couple of weeks later on the 1st of July this year. And it said that the High Court was bound by a previous legal case and that the Attorney General essentially remains above the law. So we lost. However, although we expect we might have a few grumbling words of support in the ruling, especially from the younger judge, which might have perhaps allowed a foot in the door for a Court of Appeal path, we did not anticipate that the judgment would employ really strong legal language as emphatic as anomalous, and literally spelling it out that the only court that could freshly rule on this issue of justiciability was the Supreme Court. So strong, in fact, was the wording in our favour to appeal to the Supreme Court that we took the unusual route of applying for what's called a leapfrog certificate. Now, if successful, a High Court judge would grant a leapfrog certificate permitting direct appeal to the UK Supreme Court, bypassing the Court of Appeal. This time we're under tremendous time pressure to both raise the necessary funds and make the actual application itself to the High Court, because you only have 14 days from when the judgment is made. Again, we filed the application with minutes to spare on the 15th of July. The Attorney General filed an objection, which was completely ignored by the court, because on the 11th of August, we were granted the certificate, and then you have 28 days to raise the funds and do the work to submit what's called a permission to appeal application to the Supreme Court. The deadline for filing was Monday, the 8th of September. I'm pleased to say that we raised the necessary funds and the permission to appeal application was submitted on Friday, the 5th of September. And today, 24 years on from when my brother was murdered, we served those files on the Attorney General. They now have 14 days to respond with their own grounds. To be honest, there's not a lot they can add to the weak objections they already filed opposing the leapfrog certificate application, which the High Court judges completely ignored. The Attorney General is skating on very thin ice. Yet, desperate to retain his archaic powers, where his fiat or permission is required. The only other person to enjoy such immunity is King Charles III. One only needs to look at historic high-profile cases to see why he chooses to use his trump card when it is useful to cover up the truth. Bloody Sunday, in 1972, British soldiers shot dead 13 unarmed civilians in the north of Ireland. The first inquiry was widely dismissed as a whitewash. Families sought fresh inquest, but the Attorney General's powers blocked them for decades. It was only after the Savile inquiry in 2010 did prosecutions proceed. Both the British Army and government were involved in that cover-up. Take the Hillsborough football stadium disaster, where 96 football fans died in a crush. The 1991 inquest returned accidental death verdicts. They excluded key evidence. Families made Section 13 applications for fresh inquest. All were refused by the Attorney General, immune from judicial review. You couldn't challenge that decision, those decisions. Only in 2012, after the Hillsborough Independent Panel report, were new inquests ordered, finding this time unlawful killing. Both the police and government were involved in the cover-up this time. Now, in both cases, the truth came out because of political pressure and independent inquiry and the relentless fight by victim family members. If the AG's immunity had been removed and their decisions subject to legal scrutiny, families would have had truth and justice much sooner. This is why what I'm doing is so important, and it has to be decided in the Supreme Court. It's not just an issue that concerns me and my family. It affects any family fighting for truth and justice. So, as it stands, our application will be put in front of a panel of 3 Supreme Court judges who make a decision on whether to grant an appeal hearing or to refuse permission. The odds strongly favour it being granted, in my opinion, simply because the application has already been through the High Court who issued the certificate, rather than this being a kind of out-of-the-blue Supreme Court application. Add to that the fact that the judge, remember the younger one, who actually ordered the preliminary issue hearing in the first place and then granted the leapfrog certificate, is actually the chair of the administrative courts entrusted with overseeing modern judicial review. His decisions carry a lot of weight. So finally, let's have a quick look in the future. If permission to appeal is granted by the Supreme Court, and if we can raise the substantial funds required for this next phase, we'll be at the Supreme Court for an appeal hearing in the late summer of 2025, just ahead of the 2026, just ahead of the 25th anniversary. If we succeed at the Supreme Court, the case goes back to the High Court, and I would expect the judicial review to be heard sometime in 2027. If we win the judicial review, then Geoff's inquest would be reopened sometime in 2028-29. And for the first time, evidence of controlled demolition of all 3 towers would be properly examined in a court of law. This journey has taken years. I hope Geoff finally gets the proper inquest he was denied almost 3 decades after 9/11. That is the long road to justice we are on. And I'll leave you with this thought. Thank you.